I would testify. I would do demonstrations. I'd give lectures. I'd give summations. Or I'd do what I do best. I'd try the case. I'd love to try the case.
Would you be going back to Ukraine? Are you going to? Or are you telling us you would try the case?
I don't know if anybody would have the courage to give me the case. But if you give me the case, I will prosecute it as a racketeering case, which I kind of invented anyway.
So I'm so confused. So is Rudy saying he's going to prosecute the president for racketeering? It's fascinating. I hope Democrats were taking notes there. So anyway, a federal judge, that's Rudy. I don't know what it means, and neither do you, so let's not pretend we do. It's just entertaining to watch, I guess. But a federal judge dismissed a lawsuit brought by former Deputy National Security Advisor Charles Kupperman regarding a subpoena from Congress to testify in the impeachment inquiry. Now, the suit had sought to answer whether the White House could block the aide from testifying before Congress. Yet in a ruling on Monday, the judge agreed with the attorneys for the House of Representatives that the question was moot because the House Intelligence Committee withdrew its subpoena in November. The judge also dismissed two of Kupperman's concerns, the possibility of the subpoena being reissued or being punished for not complying in the first place. Had the House lost the case, it could have further impeded efforts to get Trump administration witnesses to testify. Had the House won, it could have had a major impact on the impeachment inquiry. As former National Security Advisor John Bolton has said, he would be bound by whatever the court decided in the Kupperman case. Well, the Kupperman case has been decided. What does it mean? Let's find out. State Attorney for Palm Beach County, Dave Ehrenberg, is here. Also, MSNBC legal analyst Danny Cevallos is here. Danny, what's it mean?
It means the case is mooted. We don't really get a decision on the Kupperman case. But to understand this, we have to go all the way back to 2008, to the Harriet Miers case, in which the court held that there was no absolute immunity, but it left a crack open in the door for issues of national security. So you fast forward to 2019 and the Don McGahn case, where Judge Ketanji Brown holds that there is no absolute immunity. But perhaps more important, the administration chose to make a vague, amorphous argument that because Don McGahn was in the White House, he was in the vicinity of national security, so he may have picked up a sousant of it so that he should be allowed that national security protection, that absolute immunity. And in terms of betting, this was like putting that argument with the Detroit Lions as opposed to the San Francisco 49ers. This was not the best game to bet on national security as an absolute immunity issue. And so Judge Brown dismissed that argument when the administration might have won if it was used with a Kupperman or a Bolton. But they never got that opportunity, and now they don't quite have as good a law as they might have from the 2008 Miers case.
You know, Noah Rothman, I know you have a question for Dave Ehrenberg, but I'm just curious what your take is on John Bolton first. Do you think we're going to see John Bolton testify?
Probably not at this stage. There's just no appetite for it among Republicans, even though I think we really should. But also, I mean, this is part of what I think is probably a pretty clear Democratic failure in their strategy. I mean, we were talking about how there's all this cosmetic disunity among Republicans earlier in the hour. The real effective disunity we've seen in impeachment has been from Democrats. Democrats have cast votes against the articles. And now we're seeing Democrats arguing essentially with themselves over how a Senate trial should look, but essentially conceding that the impeachment inquiry phase was rushed. We got a favorable ruling from Democrats on the McGahn subpoena. And in the appeals court, they said, listen, the articles have passed. Do we even need to deal with this anymore? The venue where he's supposed to testify is essentially shut. And the Democrats are now arguing that even though they didn't, the process is done, they still want to hear these witnesses testify. It's a very similar story with John Bolton. The argument the Democrats are now making, Danny, I think you would probably agree, is that because we had this very urgent issue on our hands, that you needed to pass these impeachment articles as soon as possible and move on to the trial phase. They're now arguing to slow everything down. It sort of exposes the fact that the real problem for Democrats was that a lot of their members were very uncomfortable with the impeachment process.
Exactly right. No, I totally agree. And that's the challenge with these congressional subpoenas, is that there's the additional dilemma for Congress of, do we want to take this battle to the courts, knowing that time alone will probably run out the clock and the administration will likely win. So they have to have an additional layer of strategy. But keep in mind that theoretically the House could impeach on additional information. Right. The fact that these are delayed, the delivery of the articles of impeachment, could allow the House to continue investigation. And then, of course, the Senate theoretically could subpoena witnesses as well. These are all things that could bring this conflict right back into the light.
Yamiche has a question for Dave Ehrenberg. Yamiche.
Good morning, David. I have a question about the judge's writing. He wrote that he would essentially have had to balance both Congress's will to want to investigate with the White House's essentially their ability to want to remain private and have executive privilege. When we look at kind of going forward, is any judge going to want to touch this? Is any judge going to want to say, at least in a timely way, this is who wins here? And how realistic is it for us to see anybody be forced, actually legally forced, into testifying, given this judge's ruling?
Yeah, Yamiche, I think the key ruling, as Danny said, is the Don McGahn case. Judge Ketanji Brown came out with a very powerful ruling that sets the precedent in cases of executive branch testimony, saying that Don McGahn needed to testify that the claims of all this immunity didn't hold any water. And that's why that even if John Bolton is subpoenaed and even if he says that, hey, he is going to fight it in the courts, it's a bad look for him. And I think he's going to lose because the key precedent now is that Don McGahn case. And so I think it's going to be a loser. Now, as far as what was said earlier from Noah, the Democrats really had no choice, because if they fought the subpoenas all the way up to the Supreme Court, we'd be in mid-2020, late 2020, and the public didn't have the stomach to have an impeachment trial right before the election. So John Bolton and his lawyer, who actually is the same lawyer for Kupperman, left the Democrats with no choice. They had to move on. And by the way, there was nothing to prevent John Bolton from testifying voluntarily like his subordinates did, Dr. Fiona Hill. That was the patriotic thing to do. But instead, John Bolton decided to monetize his testimony by getting his $2 million advance from Simon & Schuster in his upcoming book.
So Dave, if Kupperman now is moot and the judge has decided that that case is not going to move forward, McGahn is the precedent, right? And if McGahn is the precedent, then in the future, people in the position of John Bolton will need to go testify. And whether they are granted immunity or not will depend on the situation.
Well, I think that's right, except the McGahn case is on appeal, but it's still precedent. And so until that is eventually decided, that's out there. Now, John Bolton could still say, well, I'm going to, the Kupperman case was dismissed because it was moot. If I'm subpoenaed, I'm going to take it up the chain. But again, it's a bad look for him. And I think that he should stop making excuses. He should go ahead and start doing the right thing and being patriotic and testify. Also, another thing is, by not subpoenaing him beforehand, the Senate could now subpoena him, and then it would be up to Chief Justice Roberts to make that decision. So you wouldn't have to wait till it goes all the way up the court ladder. It is, I think, an interesting strategy to say we're not going to subpoena Bolton during the investigation, but we're going to leave it up to the Senate to subpoena him. Of course, if you don't get 4 Republican senators to go along, there is no subpoena, there is no Bolton testimony, and the whole thing doesn't happen. But there at least is a chance in the Senate, whereas if you did in the House, it would take a year to get a final decision on it.